Please be seated. Good afternoon. We're here in a case once again, CV140240, in the Augusta Benoni. Each side will have 20 minutes for their argument. You may say, you may save whatever time that you wish for rebuttal. You'll have to manage your own time, and you can keep track of the time with the clock on the podium. The argument today is being video recorded, and in a day or two it will be on YouTube. So you may be YouTube stars. We've read the briefs and we've conferenced the case, so we're fully familiar with the facts. So if you want to just start right in on your arguments, you're welcome to. Counsel, you may begin.
And I'll reserve 3 minutes.
Thank you.
All right, Your Honor, as you know, this case involves the Arizona Beneficiary Deed Statute found at ARS 33405. The statute provides that an owner of real property can record a deed during lifetime, conveying on their death that property to a third party. An owner is defined as the person who executed the deed. So the question before this court is who can be an owner under ARS 33405, and more specifically, who can be an owner. The question here is Augusta Ganoni, whether or not Augusta Ganoni, Gusty to her friends, was the owner of the real property when she executed the beneficiary deed, conveying the property to Whitney Sorrell.
Because I thought that her trust owned the property.
It did, and so I'll expand on that as well. The question really is did she own the property? At the point in time that she signed the beneficiary deed, she owned the property as trustee of her revocable trust. She executed the deed. It said Augusta Ganoni, as trustee of her trust, conveys the property to Whitney Sorrell on the death of Augusta Ganoni, and signed by her as trustee of her trust. So the question then is, when she holds it in that capacity, is she the owner of the property? The answer is a definitive yes. Earlier, about a month ago, Division 1 of the Court of Appeals decided the case of Pinamaneni versus Registrar of Contractors. In that case, the plaintiff was attempting to obtain recovery from the Registrar of Contracts Recovery Fund. In order to do so, the statute required that he show he was a person injured by a contractor. One element of that was to show that he was the owner of residential property. Well, Mr. Pinamaneni, just as Gusty Ganoni here, had his property in a revocable living trust. He was the trustee, he was the beneficiary, and he was the creator of the trust. Gusty was all those things as well. The Court of Appeals found that even though he held the property as trustee of his trust, he was the owner.
That was in the context of the Registrar of Contractor Statutes, Counsel?
Yes, it was. Yes, but still determining what does owner mean in the context of a trustee with a revocable trust.
Is your argument that the term owner means the same thing in all statutory schemes?
I believe if you read Pinamaneni with PV Orbit, which also found that the Williamsons in that case owned their property the same way as trustees of the revocable
mechanics lien
trust.
statute, right?
Yes, and that court found that the Williamsons were natural persons holding their property as trustees of the revocable living trust.
All right, let me ask you a question. There appears to be then a conflict between the trust and the beneficiary deed in this case?
I don't believe so, Your Honor. And even if it is a conflict, as of the date of Auguste Ganoni's death, if we have a valid beneficiary deed, that house is no longer in the trust and it's not governed by the trust.
Well, let me ask you a hypothetical question then. Let's say that there's a conflict between the trust document and the beneficiary deed. How does 33405 resolve that conflict?
It transfers the property on the death of the owner to the person who is designated in the beneficiary deed.
Where's the language in the statute that says that? I know there's language that says if there's a conflict between a will and the beneficiary deed, that the beneficiary deed is what guides the distribution. Can you show me in the statute where it says the same is true as to a trust?
It doesn't specifically say the same is true in trust, but it's the actual terms of the...
Counsel, what does the statute say about trusts at all?
The statute acknowledges that a beneficiary deed can be executed to transfer property to the trustee of a trust, even if it's revocable.
Is there any language in the statute that says a trustee can transfer property?
It does not, but it does not prohibit it either.
A corporation can own property, right?
Yes,
But a corporation cannot die.
correct.
We would probably read 33405 together as saying it doesn't really apply to corporations.
I say that's true, but a revocable trust is a different entity.
Okay, so if we're on this spectrum where ownership alone doesn't matter, and the entity's form has some significance, shouldn't we read the statute then as the legislature wrote it and apply it only to those persons who are expressly mentioned or could conceivably fall within the definition?
So the definition is person, and Auguste Ganoni was a natural person, even as trustee of her revocable living trust.
Steve Jobs was a natural person as the chair of Apple, but that doesn't mean that we disregard the corporate formality. And here, I mean, it seems that there's an incredibly steep, slippery slope to your argument, which is that if we're going to disregard the importance of the form of the trust for this purpose, what does the trust really mean? Why do we take it seriously as an entity at all when it's grantor, beneficiary, settlor, all in one person? Do we really need to observe that anymore?
You know, the revocable living trust is a unique entity. It's not like an LLC. It's not like a corporation. It's not a separate entity in many, many ways from the person who creates it, who's the beneficiary, and who's the trustee.
Well, then
For
what's
instance,
its purpose then?
it's an estate planning tool to avoid probate. So let me tell you that the IRS, you still use your same Social Security number. If I create my revocable living trust, it's still my Social Security number. I still report all that income. The IRS ignores the trust because it is an estate planning tool.
But if you're going to use these sorts of tools, don't you have to use them correctly? I mean, there are risks to using dodges around the rules that apply to those who don't use these tools.
In this case, I think they went together very well, and they accomplished Gusty's intent. What she wanted was, no matter what happened with her trust, for Whitney Sorrell to get her house. Under the statute, if that deed is in place, it conveys the interest to the designated grantee beneficiary effective on the death of the owner. So the moment that she passed, it did pass that to him. And then the rest of her property was still in trust and went in accordance with the trust terms.
Would a title insurer insure such a deed?
I'm sorry?
Would a title insurer insure such a deed?
I think they would. They're used to beneficiary deeds.
Yeah,
you know,
but
they're-
by natural persons, not by entities. And
But Gusty, as trustee of her trust, is a natural person under PV orbit. Whereas Steve Jobs, as chairman of Apple, nobody would say that he is the entity of Apple.
Well,
you know?
if he owns, most of the stock or all of the stock, wouldn't he be Apple at that point?
Well, that might be then,
What if it's Peter Swan LLC, a one-member LLC?
it's not the same. An LLC is just not the same as a revocable trust. It's
And I would have to agree that Peter Swan LLC would be a very unusual animal altogether. I don't know what that would say.
Yeah, it may not be accepting members.
But it seems like under your scenario, your client gets the benefits, whatever they may be, of having a trust, but none of the consequences of having a trust.
Well, so with the revocable trust, at any time, she could have said, I revoke this trust and I'm just going to own my property outright.
But she didn't.
But she didn't. But the only time that she couldn't do this was after her death. Again, that's why the revocable trust is really a probate avoidance and estate planning type tool. It's not like an LLC where we're trying to get protection.
But
There's no protection from creditors with
But
that
she's not only
revocable
trying to
trust.
take advantage of an estate planning tool, she's trying to take advantage of a statute that defines a specific type of deed. And if the statute doesn't apply, there are still ways to achieve the intent. For example, she could have conveyed to the trust as an individual when she created the trust a life estate in another, namely herself. And she could have conveyed a residuary or a remainder interest, I suppose, to her lawyer. Why did she need to do this under the statute?
Well, again, the statute was brand new when Mr. Morgan, who was the attorney who did this for her, did it. So he was trying to take advantage of that ability to transfer to Mr. Sorrell directly this property, even though until her death, then she held it in trust. I see a real benefit to it in terms of if I have a house and I've got a little bit of a mortgage on it, I want to leave it to you. I can leave it to you subject to the mortgage just by doing the beneficiary deed, and then all my other property can go to whoever else I want it to go to.
You can obviously do that, but the trust sort of creates an extra layer. Now, I'm not quite sure. There seems to be something that must not be in the record about how it's proper to do this to one's lawyer, but that's leaving that aside for a moment. If you choose to place your property into a non-traditional form of ownership or an indirect form of ownership, don't you have to observe the formalities that go along with that?
Well, let me direct you to ARS 1410815 that says all powers over that a trustee can exercise all powers over the trust property that an unmarried competent owner has over individually owned property. So in other words, the trustee can do anything with trust property. So Gusty as trustee could do anything with her trust property that she could have done as the unmarried competent person she was if she'd held it individually.
Well, but I don't think any of us take issue with that. The fact is, though, that she has created a trust. She has to operate through that legal construct. The fact that she can operate outside of that construct, if the trust doesn't matter, then that seems very odd to me.
We're not saying the trust doesn't matter. What we're saying is 1410815 says that an owner who owns property individually can sign a beneficiary deed. If you read that with the beneficiary deed statute, and a trustee can do the same with trust property.
Not if ARS 33405 only applies to natural persons, then it doesn't say that. Now, there's a restatement of this trust in 2012, and your client stipulated that that was a valid and enforceable restatement, correct?
Yes.
And in that, Ms. Ganoni gives the property to someone else and has a very specific distribution of $10,000 to your client. So you keep on talking about the 2002 beneficiary deed. It's a revocable trust. Is there any reason why Ms. Ganoni couldn't change her intent and decide to not give the property to your client?
She could, but if that beneficiary deed is valid, it was never revoked. The statute 33405 has a very specific procedure for revoking. You have to revoke it with a recorded document with the county recorder.
Well, then
Nothing like that was
why
done.
the stipulation that the restatement was valid then? It would seem that your position would be the restatement was invalid.
The restatement was still valid. It still governed trust property up until her death, and then at death, any property that was still left in the trust, which this house was
The
not, because
stipulation
it
was
automatically went
Counsel,
to.
the stipulation was it was valid and enforceable.
And wouldn't this
Yes.
then be the case where statutory language would be important? Because the legislature obviously thought about this when it included in 33405 the idea that the beneficiary deed trumps the will, right? Doesn't say that about a trust. So how are we to conclude what the legislature wanted to do with a trust?
Again, I will say just the fact that it didn't say that a trust cannot revoke a beneficiary deed doesn't mean that we now don't have to follow the rules for revoking the beneficiary deed.
Open, right? Doesn't it mean the field's wide open? The statute's silent on it. The legislature didn't say anything except you want to invoke the benefit of a statute.
The definition of owner is a person, and she was a person under PV Orbit, under the recently decided case, under both of those, she was a natural person. She was a person who owned that property, and that is all that's required for her to be able to execute that beneficiary deed. And then on her death, as the owner, it transferred it automatically to Whitney Sorrell, regardless of what the trust said.
What if she's the trustee for someone else, okay, and she executes such a deed? Then your statute that you cited that says she can do anything with trust property that an unmarried competent person could do, whose death do we look to then?
That's a different case than we have here, so I am not sure.
But it helps us understand the statute. So we wouldn't know whose death to look to determine the beneficiary deed, right? If it's the trustee's death, I assume your argument would be the same. But if it's the beneficiary of the trust's death, then we're completely in the wild.
Then we have to look at who's the owner. But luckily, we are not in that situation. And again, the recently decided case, that case, says when you're all those things and it's your revocable trust, you have the power over the property and you own it. Again, PV Orbit also says that she was a natural person. She owned that property as a natural person. The statute allows a person who owns it to sign that beneficiary deed. And I'm down to 3 minutes, so I will reserve the rest of my time. Thank you.
Thank you, counsel.
May it please the court, Kevin Parker for trustee Joy Gard Morton. We think this is a simple and straightforward matter of statutory interpretation. The beneficiary deeds statute clearly on its face applies only to natural persons. It does not apply to trusts for a whole host of reasons. We think our interpretation is supported by all of the traditional constructs for statutory interpretation. The purpose in context of this statute in the first place, what need does it fill? Why is it there? That's number one. Number two, the plain language of the statute. Number three, have other states addressed this, and what have they said? They have, and they're aligned with ours. Number four, is there any national authority that has spoken on this? And there is. The National Conference on Uniform Laws has spoken on this, and they're very specific. And then the other point is the flip side. Well, what would happen if the opposition's interpretation is accepted, and there would be a whole host of problems. The statute would need to be completely rewritten. For example, what happens with a corporate trustee? Corporate trustee can't die. Is it the death of the settlor or the beneficiary? Is this only going to apply to trusts if it's the same person as trustee, settlor, beneficiary? All those basically you need to rewrite this from scratch, Your Honor. So all of those 5 tenets of statutory interpretation are aligned and support us. The bottom line is this is a trust asset. The decedent did a trust in 2012. It's been stipulated as not only valid but effective. That trust disposes of this trust asset in a particular way. And we think that,
I mean, the question is, did that trust still own this trust asset or still own the level of title it thought it did in 2012?
well, a beneficiary deed, Your Honor, obviously is not effective to transfer immediate title. So
No, but it's effective to transfer an immediate interest. When you get a beneficiary deed, I mean, I've never heard anyone suggest that a beneficiary deed is properly conveyed is revocable at will, right? The recipient of the beneficiary deed has an interest. That interest may be contingent. That interest may be deferred, but it's still an interest.
Your Honor, I disagree in a sense because the statute says that in effect there's the beneficiary has no interest to prevent transfer of the property, for example. It's sort of a will. If you're a beneficiary of a will, you don't have an interest. It's a revocable instrument unless and until the person dies without changing it.
Really? I mean, if that's the case, why would the statute say that the beneficiary deed trumps the will? It would seem to me that it says that because the legislature recognized that a validly transferred beneficiary deed creates a future interest. Back to all our favorite subject in property class. Isn't there a future interest that has been transferred upon the delivery of that deed?
I don't believe so, Your Honor, and I think it trumps it for this reason, and that is the legislature, and this also explains, in my view, why it doesn't make any sense to include trusts. It fills a gap for the non-probate. Trusts already are outside probate. Wills, you have to probate an asset. So with the niche that this fills is non-probate transfer of property held by an individual in their natural person capacity. So then given that that's the purpose of this, then the legislature has to decide, okay, if it's an attempted change by will, how do we balance those policy considerations? One being transfer outside of probate, which has benefits. The other being we want to follow the person's last intent. For example, the will may say, I don't want that to happen. So that there's a balancing by the legislature. In the trust context, and this is another reason why it doesn't apply to trusts, in the trust context, there is no such balancing because a trust already passes outside of the probate. So the legislature does not have to decide, do we want to follow the last intent that has benefits, or do we want to follow the statutory non-probate transfer? That's the balance.
I understand the argument that, there was never a valid conveyance here because the trust doesn't meet the elements of the statute. I can see where you're going with that. I'm concerned that you may be going a little too far if you're suggesting that beneficiary deeds are really sort of sweet nothings that are revocable at will until the death of the transferor. That to me would seem to obviate the need for the statute at all. I mean, are you suggesting that I could give a beneficiary deed to my house to anyone I feel like every day, and just when the game of musical chairs ends, the last person standing gets the house?
Absolutely. That's why it's a revocable instrument, Your Honor, is that, and the statute even says if there's multiple beneficiary deeds, the last one controls. It's sort of like a person who was named in a prior will. They don't have any interest, but they have standing to challenge the later will. That doesn't mean they have an interest, Your Honor. So back to the argument about the purpose and the context. The purpose, obviously, is to fill a need for transfer of property owned in an individual capacity. A trust already transfers trust property outside of probate. So this narrow niche that it fills is person owns property as a natural person. how can they do that? How can they transfer that upon their death without having to do a trust? And in fact, the supplemental citation of authority that we've cited, the uniform laws, on page 26, here's the comment. The transfer on death deed is likely to be used by consumers for whom the preparation of a tailored inter vivos revocable trust is too costly. So you don't use a beneficiary deed for trust property. You use a beneficiary deed for own personal, natural person owned property to transfer it on death outside of probate. You don't need the trust. With respect to the comment by Judge Gould and Judge Swan about, what happens in a conflict, the statute doesn't address it because it doesn't apply to trust property. And second, as I just mentioned, if the legislature were to want to be an outlier, every other state does not that, but to the extent the legislature wanted to consider, well, how are we going to handle the trust type beneficiary deed? That's the balancing of policy considerations. With a will, the balance is the deed trumps the will. But in my view, that's because there's the efficient purpose of transfer outside of probate has to be weighed against the benefit of adopting the agreed last intent of the person. That doesn't apply in the trust scenario. There is no counter policy consideration. So my point being, it doesn't apply to trusts. But if you just loaded trusts in for some reason, you can't just assume that the beneficiary deed would trump the later trust because the policy considerations don't apply.
But returning back to the revocable nature of this, the statute says the deed is revocable, but only if there are certain procedures complied, right? Recordation and all that sort of stuff. So if one just does go signing beneficiary deeds every day without following the procedures for revocation, that's not an effective revocation.
Well, somewhere in the statute,
I think it's
it talks about a successor.
It's section F. At least that's what I was focusing on.
Well, that talks about more than one owner, Your Honor.
No, a beneficiary deed may be revoked at any time by the owner, or if there is more than one owner. Blah, blah, blah. To be effective, the revocation must be executed and recorded, right, in the office of the county recorder. So it doesn't seem to me that these deeds are quite as evanescent as you suggest they might be. They have to be. If you're going to revoke it, you have to do it in accordance with the statute.
Yeah, you're right. I'm not finding what I was looking for. But in terms of the revocation concept, I think everybody agrees that there's a change of ownership. Well, first off, it doesn't apply to trusts. Second, so you don't even get to the revocation.
Yeah.
So in terms of the revocation, the change of ownership obviously revokes the deed. If I sign a beneficiary deed and then I transfer the property to someone else, that doesn't travel to the new owner. The new owner is not bound by the beneficiary deed.
If you sign a beneficiary, assume no trust, you sign a beneficiary deed giving me your house.
Upon my death.
Upon your death. And then you sell the house to Judge Gould. What happens?
It's nullified. And there's a good explanation of that in the Uniform Law Commentary. You're right, it doesn't say that. I think it's just presumed, Your Honor. It doesn't. A beneficiary deed cannot prohibit the owner from transferring.
But it's
like
very clear under subsection F that the only way you can revoke the interest is to comply with subsection F. So how would we presume that a transfer, I mean, wouldn't that just be like any other transfer of an interest I don't have?
Well, it's like if I leave,
Transfer.
I leave you my house and my will, and then I sell it, and then I die, and you go to the owner I sold it to and say, hey, Parker left me his house in his will, and now he's deceased, so it's my house. Well, the answer is no, it's not your house. That's the same concept, Your Honor.
It's the same concept, except it's a different law that reads differently. So, I mean, it may not be the same concept. It's a fair rejoinder. But isn't the critical distinction there that you didn't convey anything to me? You just left me your house in your will. At this moment, I have nothing, because you're alive and you can change your will anytime you feel like it. If you give me a beneficiary deed, that gets back to my future interest concern. I have something until you properly revoke it under the statute. Isn't that a material difference between using a will and using a beneficiary deed?
I'm sorry, Your Honor. It was G that I was referring to. My colleague located it for me. If an owner executes and records more than one beneficiary deed concerning the same real property, the last beneficiary deed that is recorded before the death is the effective deed. So it can cycle through, like you mentioned. I think the revocation part of the statute identifies a protocol for revocation. If you want to, here's a way to do it. I don't believe it is, because it's not a present interest, I don't believe it's the only way to do it. A distinction would be if I have a life estate in my property and you're a beneficiary. You have a real interest in that, because it is, I've just retained a life estate for myself, and you have a present beneficial interest in that house. That's different than a beneficiary deed. And going to your point, it says that's the only way to revoke. Well, it says that, but it also says another way to revoke, right in the statute, another way to revoke is just to do another one. So it's not it's not exclusive, Your Honor. And by its very nature, another way to revoke or terminate or nullify, whatever the word in the, I think the statute uses, or excuse me, the Uniform Law Comments use the word ademption. It obviously doesn't apply if you sell or to another property. It's just, the whole concept is it doesn't apply.
So
what do you call it?
So if you have a validly recorded beneficiary deed and then the owner sells the property, the beneficiary of that deed then has no cause of action against the owner based on his future interest in the property.
Correct. Absolutely not, Your Honor. Has no interest. And I think that's the whole point of the statute is it is a will substitute, but the wrinkle is a will would pass by probate. This doesn't. So it incorporates the same principles and concepts. No right, another one, just like another will, trumps the prior will. Here's a way to here's one way to revoke in the statute. Here's another way to revoke in the statute is just to do another one. And as a practical matter, if the owner transfers it, then that nullifies it as well. And that also leads back to their argument, which is, well, let's try to mush this together and say the trustee is the owner. Well, that, even if you get to that point, we have successive trustees. We have Ms. Ganoni as the original trustee. Then Mr. Sorrell actually did an amendment that made himself the trustee in 2011. So at that point, under their theory, he's now the owner. And then the 2012 trust changes the ownership again under their theory, which is the trustee's the owner, because Ms. Gard-Morton then becomes the trustee. So the point being their argument is they have a dead end everywhere they go, but that all leads back to the simple answer is the right answer to begin with, which is it doesn't apply to trust property. The entire purpose is this niche for natural owned property that by the will would pass through probate. So can we legislature think of some way to do that, because a trust already passes outside of probate. And so what 20-some states have done is, okay, for natural person owned property as a will substitute, we'll allow this beneficiary deed concept. But given that it's a will substitute concept, it's revocable, it's completely revocable, and here's one way to revoke it, here's another way to revoke it. It doesn't prohibit the owner from transferring. The beneficiary has no rights other than, like a beneficiary named in a prior will, if they think the later will is the product of undue influence, or if they have some reason to challenge it, they have standing, because if that later will is invalid, I may have a shot. This case, Mr. Sorrell has stipulated that the later trust is valid and effective. So we don't have that issue. That issue is off the table.
Your reading of the statute may well be correct, but doesn't it create sort of a shining example of a violation of the rule against perpetuities at that point? I mean, this is an interest that can't possibly, under your view, this is an interest that is at best worthless and possibly violative of the rule, except for the fact that the legislature said it exists.
I'm not an expert on the rule against perpetuities,
don't
but I
think
think it's.
and none of us are.
Are you ready for that question?
But I think it doesn't violate it because there is an end game. It is when the when the owner dies, and then the interest of the beneficiary deed recipient takes hold, and they are the complete owner. So it's not a rule against perpetuities issue, I don't think.
But in this case, in any event, your position is the beneficiary deed was invalid from the get-go, so it never left the trust because the statute was not a means by which to execute the beneficiary deed, correct?
Yeah, absolutely. And it gets back to Judge Swan's point is that these are statutory rules. You have to comply. To me, it's an example is, okay, this person did a will, but they only have one witness, and then they pass away, and everybody agrees, well, this is what they intended, et cetera, so let's just pretend they have two witnesses. Well, you can't do that. You have to comply with the statute. This statute has a specific purpose for natural person-owned property as a will substitute. It gives you an opportunity. It's not in it. Given the opportunity, you have to comply with the statute.
With the PV Orbit case, do you want to comment on that at all? I know that was a mechanics lien case, and the court was talking about equitable interest of a trustee and legal title of a trustee, and then there's the statement about the trustee owns the property. I guess one could read PV Orbit in the sense of the statute defining a dwelling. I think that was the language in it. The trustee in that case owned legal title and therefore qualified as an owner under the statute.
Yes, Your Honor. I think all of these cases that they cite to where they just sort of ignore the trust are driven by the purpose and intent and structure of those particular statutes. It is, we're just going to disregard the entity in this circumstance because we think that would be consistent with, for example, a deficiency judgment. If somebody owns their house in trust, can they still take advantage of the deficiency judgment laws? The court says yes. But those are policy driven to fit those particular facts and the purpose of the statute. So I think that is, I hope I answered your question, Your Honor. If there's no further questions, I will step down.
Thank you, Counsel.
Thank you.
So apparently my colleague says that some statutes it's okay to say that the trustee is a natural person of their revocable trust, but other statutes it's not, in particular the beneficiary deed statute. That doesn't make any sense. If we are going to say that the trustee of a revocable trust is a natural person, then we need to say that for all purposes. So in this case,
I'm sorry, but what do you do with the 2012 restatement of the trust, even assuming everything you just said is correct?
so I want to go to the statute, which I think answers that question. So the statute specifically says that if the owner has put this beneficiary deed in place, that effective on their death, it transfers the property automatically. So this is as a matter of law, this is a transfer. Just like if I recorded a deed to you directly right now, that's automatic. It's yours now. It's
mine unless you revoke it or give it to someone else.
Well, I'm talking about a regular deed. But with the beneficiary deed, at that moment of death, that was Whitney Sorrell's property.
But again, that assumes that the original deed was valid, though.
Right, true. So, but going back to the 2012 trust, the 2012 trust governed that property right up to the moment of her death. So during that time, anything that she could do or that another trustee could do with that property, that was governed by the trust. But on the instant of her death, by a matter of law, it was transferred to Sorrell, so the trust had nothing to do with it. It only affected trust property in the trust at the moment of her death and thereafter. So, so that would be, that's why the trust doesn't provide any conflict, for one thing, and it also doesn't revoke. The only way to revoke is with a recorded document revoking, and there was no such thing. There's nothing in the statute that says you can't use this with a trust, nothing at all. The statute itself recognizes that you transfer to the trustee of trust, and again with PV Orbit, we have a clear ruling that the trustee of trust, if it's a person, it's a natural person, and they can be the owner. And Pinamanini is exactly the type of case that we have here, with the person who signed that beneficiary deed at that point was the trustee, the beneficiary, and the settlor, and owned that property as a person. So, thank you, Your Honors.
Thank you, counsel. We'll take this matter under advisement and issue a decision in due course. Thank you.